The market capitalization of the coin is used to summarize all that is taught in this video. Additionally, I would ask that you support my channel by liking it and subscribing to it so that you can stay up to date on future XRP news as well as other cryptocurrency news in general. Take a look at this now, shall we? The deadlines for XRP-CC motions and hearings are established by the court, following the most recent order that was handed down by the court, which approved in part and denied in part the petition for summary judgment. An update has been provided about the Ripple XRP case. This action was sent to a district judge for resolution, and dates were set for the filing of motions. By a circuitous route, the judge concurred with the ruling of the court for the Special District of New York, which stated that programmatic sales of XRP are not considered to be securities. The case against Ripple is planned to continue for the next few days. The court has reportedly set dates for future motions and hearings on claims that are still pending, as stated in the most recent document that was presented to the court. The CEO of Ripple, Brad Garlinghouse, made a remark that was not true about his long position on the XRP cryptocurrency. This is one of the claims that has been made. It has been decided by Judge Phyllis Hamilton that the submission of the narrowed motion to seal must be completed by the 8th of July. Regarding the motion to seal that has been narrowed down, the court will issue a separate order regarding the matter. In addition, the judge gave the parties a deadline of 28 days until July 26th to submit a notice stating whether or not they want to continue their efforts to exclude the testimony of 4 experts. The notice must indicate whether or not they intend to continue their efforts. The decision that Ripple took to eliminate both of these, the testimony of Stephen P. Feinstein and the application made by the plaintiff to exclude the testimony of S.P. Coterie and Laurentius, were both rejected on the grounds that they were neither pertinent nor pertinent to the case. Magistrate Judge Robert Illman was assigned to rule over the case in order to assist a resolution between the parties involved in the dispute between Zakhanovsky and Ripple Labs. According to Judge Hamilton, who, in agreement with the summary order given by Judge Torres of the Southern District of New York involving XRP programmatic sales, the plaintiffs were unable to prove that XRP is a security. This is due to the fact that investors rely on Ripple's efforts for earnings. XRP is currently trading at a price that is lower than $0.45 prior to the ultimate decision that Judge Torres will make. Whales and investors traded XRP during the period of time when the cryptocurrency market was experiencing a decline. Over the past 24 hours, the price of XRP has risen to a new all-time high of $0.43. Within the last 24 hours, this represents a rise of more than 4. Furthermore, whale accumulation buying by well-known investors such as pro-XRP lawyer Bill Morgan added to the rising momentum that was brought about by low trading volumes. This was a factor that contributed to the whole phenomenon. As of the time of this publishing, the price of XRP is currently trading at $0.43, having recovered from its previous low of $0.41 over the course of 24 hours. The massive buying that took place when the price dropped below $0.40 was indicative of a bullish sentiment for XRP during that time period. In a single hour, there were a total of $132 million worth of transactions. Currently, the XRP community is waiting for Judge Torres to make a decision regarding penalties and injunctions. This is taking place during the remedies phase of the Ripple vs. SEC action. The attorneys have stated that they anticipate a verdict to be reached before the end of July. Since December 2020, Ripple and the SEC have been engaged in a legal dispute that has been underway. The allegations of unregistered securities offerings through the sale of XRP are at the heart of the case, and the potential penalties are now anticipated to reach a total of $102 million. It is anticipated that the problem will be fixed by the 31st of July, alongside the possibility of a penalty of $25 million. However, due to the complexity of the case and the appeals procedure, it is possible that it will take longer, which will have an effect on the price of XRP. Since the month of December in the year 2020, Ripple and the United States Securities and Exchange Commission have been involved in a legal fight that has been going on for a considerable amount of time. This issue revolves around the allegations that the company and some of its officials engage in unregistered securities XR tokens. These allegations are at the core of the conflict. In spite of the fact that the case entered the trial phase in April of this year, there has been no news of a resolution as of yet. The key aspect that appears to be driving the action to drag on for a longer amount of time is the possible responsibility that Ripple may be held liable for. The Securities and Exchange Commission (SEC) made a commissional proposal to impose a staggering fine of $2 billion on the corporation. However, the corporation insisted on a sum that was no more than $10 million. Prior to the passage of a few weeks, the regulatory authority adopted a more liberal approach and proposed a penalty of $102 million. At the end of June, Judge Amy Jackson dismissed the arguments made by the Securities and Exchange Commission (SEC) that sales of BIASes that were tokens on the secondary market constituted securities transactions. The CC had made these assertions, whose purpose was to use the ruling to its advantage, became aware of it, and then took action in conjunction with that intention. To be more explicit, it proposed a notice of supplemental authority, in which it argued that the decision adds validity to its contention that the alleged illegal transactions of XRP do not warrant harsh sanctions, as the agency alleges. In other words, it contended that the decision lends credibility to its contention. An official response to the inquiry was provided by the Commission on July 3rd, demonstrating how quickly it responded to the probe. It argued that the case against Ripple is completely irrelevant, and the reasons for this are shown in the following list. Ripple draws attention to a specific observation that is contained inside the approximately 90 pages that make up the Binance order, in addition to making an attempt to extrapolate from that broad observation to the efficiency of the SEC's litigation strategy. The remarks that the court made in response to a motion to dismiss the acts of the SEC disclose virtually no information whatsoever on Ripple's actions or the remedies that are suitable for the violations that this court uncovered. Would you say that it is time to reach a conclusion, given the complexity of the legal process and the chance that both parties will file appeals? It is highly conceivable that the litigation will drag on for an indefinite amount of time. On the other hand, many people are confident that an official resolution might be reached as soon as this month. One person who exemplifies this would be the American attorney Fred Rispoli, who proposed the 31st of July as a potential date for the event. It was also his forecast that the outcome would be that the company would be liable to a penalty of somewhat more than $25 million, and that there would be no disgorgement. He predicted that this would be the case. The court made the decision that all of the sales that she considered to be unlawful are permanently enjoined, and she also made the decision that all of the new contracts that Ripple mentioned are not properly before her. The attorney continued by saying that this indicates that the Securities and Exchange Commission will be required to file a new case if it considers that these contracts violate her order. In the event that the drawn-out legal issue is finally resolved, it is anticipated that the price of XRP will be subject to a considerable degree of fluctuation. It is essential to keep in mind that the valuation of Ripple's assets experienced a substantial increase after each of the partial triumphs that the company achieved in 2014. Should you be interested in acquiring additional information regarding the case and the potential impact that it may have on the token, please contact us. Jones argued in his argument that the objective of the British coalition is not to destroy the United States of America. Rather, it is to combat the supremacy of a single currency and the central banks through the utilization of the United States dollar. Jones's argument was presented in the context of the overall purpose of the coalition. It was highlighted by her that the alliance is hostile to the Federal Reserve's hegemonic control over the economy of the entire world. It is possible, in her opinion, that this transition would lead to the introduction of a new currency for the United States of America. This money could be backed by gold or other tangible assets. Within the context of the current fiat financial system, which is mostly based on the dollar, Jones placed a significant amount of stress on the significance of escaping from this system. Jones is advocating for a financial system that is supported by real assets as opposed to the current system, which is based on faith and is managed by central banks. It was in the context of a comment that she stressed the significance of making the transition to a government that is based on the truth and is characterized by transparency and accountability. In its role as a new leader in the financial system, it was brought to everyone's notice by Jones that Ripple's XRP ledger, also known as the XPL blockchain, had the potential to be the leader in this new system. It was brought to